because it was the public work. Dispute begins very early in 2004. Already the dispute between NHIF and Crown has begun. So dates would help us to see, by the time you incurred all these costs, hiring engineers, hiring architects, hiring surveyors, were we aware that already we did not have good title, or we do not have possession of the land? It's something we need clarity. So I don't know if this is captured in the appendix. Clearly, you bought land for 93 million. You spent another 42 million defending it. You have a bill of 1.4 billion, even when there is no stone. Not a single foundation stone has been laid on the resource center. A bill of 1.4 billion. So I don't even know how you capitalize this asset when finally everything is done. Given all the sunk costs in the building. So we need some clarity of timeline just to see who dropped the ball. Where did the ball drop? Thank you, Chair.
Chair. Yes, on the same. That is the same page 6, with the query number 1.2, the doubtful work in progress at Karen Land. As at 20th June, there was a bill of 1,444,648,484. The actual project was 93 million. Now the bill for architectural and other things is 1.4 billion. I don't know if the cost, when costing a project, usually the architectural work and what are included in the cost. I don't know if this was different. Chair, I want you to note that the actual project was 93 million, but the architectural work for the resource center, by 20th June 2020, the fee notes were 1 billion. They were claim of 1 billion. That is almost 100 times the cost of the project for architectural and something there. By 20th June, already you know you don't have a land. There is dispute, but you are engaging professionals. 2, if you continue on the same page on page 11, there are a question I ask you, but I've come up to realize that appendix C3 is not relevant to the information you are giving us. You can go through it again. It doesn't have details. It's just a copy of a contract which does not tell us what is being done at which cost. It's just a few pages of a contract. And you have cited it several times. So I don't know if it's relevant because you have cited it in paragraph 3 and paragraph 4, C3, if it is very relevant to the query. And finally, on the dates, where my brother's question, we need to know the dates. And apart from that, you remember on the same note, I asked you about the minutes of the board to provide the technical report which was given, the BQ for the lifts. Chair, that one will really guide us, because from where I sit, Chair, there were money in the account. From where I sit, there were money in the account the board wanted to spend, so they decided to buy lifts, which is costing the money in the account. Eventually, once the money was somewhere there, they realized that these lifts are not important, but now we have the money. They decided to exclude it, Chair. Even from where you sit, you can't order for something before doing the survey. all over, and at a big cost, and then all of a sudden you say that the lifts were not viable. What did that indicate? It indicated that there was no feasibility study and there was no technical advice. So can we get, if there was technical advice, the feasibility study, if any, and board approval of buying of these particular lifts? And also the board approval of removing them and the technical report from Public Works showing that they are not viable. Because it was the Public Work and the architects who were supposed to advise you that these lifts are viable. We want them to get you another report which told you that these lifts are not viable, because somebody must be held accountable for such omissions. Thank you, Chair.
I have two issues maybe to find out from yourselves, especially on 1.1. You've indicated like the matter is seized off by DCI and DCI has communicated to ODPP. Maybe you table to us the letter from the DCI instructing you to fence. You said he instructed you to fence, but I've not seen that letter from the DCI instructing you to do so. Number two, I want also to get the court injunction barring you any development. I've seen that you've gone to get a court injunction to put a caveat. But where is any court instructions to you barring you to undertake any development? Number three, the footsteps of Mheshimiwa Ndeto, that you have already spent 1.4 billion on air. What I can say, it is, yes, it's a service you render to QS or whatever, but where is that service? What purpose is it serving? It's not there. The question I have to you is, you did it, you already paid the 1.4 for the proposed resource center, but at that time when you are committing this 1.4, and then later on you changed from the resource center to a medical center of excellence. That time when you made that decision, the land was already in dispute. So my question is, what are you trying to achieve? Yet you don't have the land itself. You have a piece of land, yes, but it's under dispute. What are you trying to achieve by investing this 1.4 billion for nothing? And number three, the head of investment. I want you to give this committee, from where you sit, this 1.4 billion, from the time you paid it, had you invested it in the normal way you're investing, how much return on investment would you have gotten from that 1.4 billion? Give us the amount we've lost as a country by virtue of that decision of the management. I wish to invite the CEO to respond to the issues.
Thank you, Chairman. The first question asked, what is the core mandate of NHIF? The core mandate of NHIF is healthcare financing, where we are able to pool resources of many contributors so that we can settle the bills for the fewer beneficiaries who claim. Now, my experience in insurance arrangements show me that organizations like NHIF collect premiums, the premiums immediately for settling immediate claims, and then invest any extra funds so that they're able to make more resources to settle additional claims. So claims are settled both from premiums collected and investment income. The second question was the board decision to acquire the land value for money. I think with hindsight and the developments that have happened, the amount of money spent has come to show that it has not ended up being value for money. We don't have information on the intentions then. Chair, Honorable Adeto asked about missing dates. Indeed, in future reports, we shall show dates for ease of flow of information. But in this particular report, Chair, the referenced appendices have dates. While we wouldn't want to take the committee back and forth from appendix back to the report, I think if we would like to have a date, it is available, only that it will take a bit of work. We note to ensure that future reports have dates for ease of flow of information. The next question was NHIF aware that the land was disputed, the ownership of the land was disputed when coming up with these projects? Given the available documents, Chair, NHIF was definitely aware. Maybe they worked on an assumption that the cases would be determined quickly because records show NHIF is a beneficial owner and the projects would continue. Our assumption as management is that the then management and board did not envision that the case would take as long as it has taken. Architects and QS bill 1.4 billion against the value of the land 993 million. Indeed, if you compared only with the value of the land, the 1.4 billion is disproportionate. But Chair, looking at the business plan, what was envisioned to be achieved out of the investment of 1.4 billion in consultants, maybe that is what the then management used to justify the expense of 1.3 billion.
Chair, I beg to interject.
Yes, Vandejo, but let me also say that the chair have just stepped out and stepping in for him. Yes, Honorable Vandejo.
Yeah, I think I disagree with the CEO trying to talk about the business plan or the projections that had been given for purpose of this resource center. Because what we should be admitting here is negligence on the part of NHIF, board, and the management at that time. Because if you see how we ended up with all these arbitration awards for consultants, is when the consultant, it has been rightly been captured in your report, when the consultant presented their reports, and I wish to draw your attention to your document on the resource center. When the consultant sent the report, you say The fee note, this is page 6. The fee notes were, however, not honored because the management had not received prior approval for the works from the parent ministry. If that is your report, I think here no further explanation is required. This is an admission of culpability on the part of NHIF board and management, because clearly they gave instructions for some design work and engineering work to commence when they did not have approvals. So once now they got the invoices, they are stuck. Against what do they pay? Because concurrence with the parent ministry appears to be a requirement or a condition, unless maybe the CEO clarifies otherwise. So this whole thing, first of all, it does not even appear as if they already agreed contracts. And were it not for time, Chair, it would have been important for us to go through the details of Appendix 2 to be able to see how each and every one of these consultants was hired. Ujenzi, Redman, Peter Scott, professional consultants. How was each and every one of them hired? When they bring their report, management says, sorry, we cannot even discuss this. We don't even have approval to do this project.
All right. And if you see how this involved, usually people have contracts. But what is coming up from NHIS is settling disputes. Most of the time, that means the process was wrong. And to my question, which I asked, if I can just follow up, now that you are investing in order to pay all this you said, and you also come to say that the investment has not realized what you intended to do, how did you then pay? And I think if you go to amendment, NHIF amendment on 2022, we changed. And I think we are going to change everything about state corporation investing, because it's not being realized what it's investing for. So that option of that investment, I don't know whether it's there in the new one, but we took it out. But anyway, you can respond. How then did you pay all this you intended to pay by the investment which yielded nothing?
Chair, just on the same note of Wandeto,
Follow up, yes.
I just went through that particular query. Once you said that the parent ministry has not approved of a work, it means the procurement was not done, because you cannot procure before approval. I don't know if I'm right, the CEO. You cannot procure before approvals.
Chair.
But in your case, you procured before approval, because it seems the matter arises when payment are now being demanded and you cannot pay. You cannot pay because the parent ministry has not done approval. Then the same parent ministry later, with consultation with the Attorney General, authorizes you to pay. You know, this is contradicting. If I'm the authorizing officer, I have not authorized you. I cannot sit with you again and tell you to pay again what I did not authorize. So I don't know. The explanation we can get from there.
Can you respond to that? So we move on to another step.
Chair, the explanation I can give at this level is that indeed there was a breach of process where authorization was sought after event, because it should have been sought before event. My supposition, because it is not based on record, is that after this ministry saw need to approve, and now with the approval of the ministry and works relying on record and reconstruction of data, and now given the approval, the NHIF didn't have a choice but to proceed and pay the bills that were incurred.
follow-up question, Chair.
Yes.
Again, just to the CEO. And Jesus said the truth will set us free. Do you see this from your heart of hearts? Do you see this as just a well-crafted and choreographed arrangement to defraud NHIF, as opposed to some well-intentioned oversight, where the intention was good, but there were maybe lapses or oversights? To me, this looks like a very well calculated design to just basically siphon money out of NHIF. I don't know, you are a newcomer, so you do not have, as much as you are the one acting, you really can talk the truth. And the good thing in this meeting, you have admitted to many things. This whole resource center and the design and whatever, and the 1.4 billion. Don't you see it as a scheme to just steal and nothing else?
All right.
Just on the same note, they better provide, the C has talked about, once the minutes are now approved, can we get the approval letter from the parent ministry before the payments were done? Let us have the record of the approval, when it was done and when the fee notes were given, because that one will lead to something else. Whoever authorized, when was it authorized, and who authorized now the payment of this, approval of these particular works?
Thank you. Now, quickly, if you can respond to that, because I'm looking at time, we want to do the 3 and 4, but these questions members are asking are very pertinent, but you respond as brief as you can.
Thank you, Chairman. About the approvals, I am promising to quickly get the documents requested and availing them to the committee. About the question from Honorable Wadeto, Chair, given my newness and what I'm having to deal with within a very short span of time, I have not had time to reflect on this, and I am not able to give a personal opinion. Kindly indulge me on this one. Thank you.
Yes.
What's happening here? You can't get out. You are now sitting there. This country, I think, let's call a spade a spade. There's been corruption. In fact, what Tito is quite right, and I've looked at it and see that the money being paid. Who authorized that? What informed him to do that? Because it looks like there's some game which was played, and people talk about corruption in this country. We want to get. I know you are new. If you are giving us a report, kindly give us that report and make your personal. You're a Kenyan. What do you think? No, we're trying to get rid of this corruption. What do you think? Make your comment on that. Thank you.
Just to guide you, CEO, if you don't know, honesty is the key to everything.
Yes.
If you don't know, just say you don't know. If you need more time on it, we all understand you're just a week there. But what they are saying is that you cannot run away from the responsibility of the office. That's all.
Chair, for now, I don't know. Let me read. For now, I don't know.
Thank you. Let's make progress. There is...
Chair, our chairman would like to say something.
Okay. Chair, you want to say something?
I wanted to put one of my board members on record. He has joined us. You recall I said the chair of finance. Yes. So he has joined us. So with your permission, maybe he can introduce himself.
In order. Who is? Proceed, please.
Good morning, Chair and members. My name is Dennis Gitari, the Chair of the Finance Committee of the Board. Thank you.
Thank you. As we Honorable Member, I plead with you to hold on to the appendixes, verification, so that we can do 3 and 4, then we come back to it. But as we proceed, take this in and maybe you can respond at a later date, at a later time. According to the 22nd PIC report, there were other claimants to the current land, which we don't know. You may clarify for us. One of them was Imuono, Olaro, Self-Group, and 8 others. This is according to PIC of 22nd. 8 other parties. Also, there was Crown Rights, Nectel Kenya Limited, Gifted Community Involvement, and all these. Cytex Limited, Ken Park Holdings. There's so many of them. What is the status now? What is the position of these claimants? This is according to the PIC of 22nd PIC report. So put that on so that you can respond later. But now I would guide that you go to number 3, unexpected, unquoted investments. Please proceed.
Honorable Chair, number 3 is on unquoted investments, and one of the unquoted investments, Chair, is the Moi Teaching and Referral Hospital loan. With your permission, I'll commence with the background.
Please proceed.
Thank you, sir. MTRH wrote to NHIF via letter, ref number ELD/MTRH /admin/1/vol 4/2015 dated 12th July 2017. Appendix D1. Forwarding a proposal requesting finance for the purchase of the radiation oncology equipment. A board paper was prepared and presented to the Finance and Investment Committee on the proposal to offer the loan facility to MTRH. The board approved a loan facility of 312,669,869.20, Appendix D2. NHIF wrote to MMA Advocates on 12th July 2018, ref number HF/HOSP/3/1, volume 1/8, requesting them to prepare a finance contract between NHIF and MTRH for approved amount of 312,669,869.20. The instructions included the total amount advanced and legal fees, which will be recovered over a period of 10 years at an interest rate of 3% per annum, to be recovered through claims payable to MTRH. Appendix D3. On 5th December 2019, draft head of terms, Appendix D4, draft financing agreements and memorandum of understanding between NHIF and MTRH were finalized and were shared with MTRH for their review and discussion. Thereafter commenced on the terms and conditions. One of the main concerns by MTRH was concerning the loan amortization schedule. The current status, Chairman, the NHIF board, or the then NHIF board, approved the execution of the contract upon review of the loan amortization form to include adjusted legal fees. MTRH and NHIF are at an advanced stage of contract execution. Chair, I am in communication with the CEO of MTRH. They have agreed on all the clauses of the contract, and the assurance I have is that I will have their signatures by Monday, 23rd of October, that is 2023. At the moment, The fund continues to recover the loan from MTLH's claims repayment at a rate of 3,019,064 per month towards repayment of the loan, and MTLH have acknowledged this recovery as the two entities finalize the execution of the contract. The balance currently stands at 221,707,664 as at 31st August 2023. That is contained in Appendix D5. Payment of legal fees of 40,883,040 was based on invoice for work done by the contracted legal firm. Review of the Memorandum of Undertaking between NHIF, MTLH, and International Atomic Energy Agency. Review of the financing agreement between NHIF and MTLH for purposes of procurement of radiotherapy equipment. Management has instituted the following actions in a bid to ensure the matter is resolved. 1. NHIF has written to MMA advocates requesting a meeting to discuss an appropriate recalculation of fees payable, that's D7. A full board meeting held on 29 September 2023 directed management to facilitate the immediate signing of the contract with the renegotiated legal fees and pursue MMA advocates as above. Chair, the second section under this is shares in Consolidated Bank valued at shillings 54,200,000. The background: the shares held at Consolidated Bank Limited comprised of 590,000 ordinary shares valued at 11,800,000 shillings and 2,120,000 preference shares valued at 42,400,000, totaling 54,200,000, as outlined in Appendix D8. The current status, Chair, on ordinary shares held at Consolidated Bank, it is true that the fund included the total value at cost of 54,200,000 in the financial statement. Management, however, having explored all recovery options provided for in its policies, considers the investment as impaired and its recoverability doubtful. It has therefore created a provision to reflect this position in its books of year 2022-2023.
Fair enough. Members, if you could just hold your horses a little bit, we move to number 4, which is page 18 of 40, so that we combine it together. If you are ready, CEO, proceed.
Thank you, Chair. Number 4 is on short-term deposits and investments. With your permission, I'll begin with the background, Chair. In June 2001, NHIF placed fixed deposit with Consolidated Bank of 600 million, Appendix E1. In August 2001, the then Chief Executive Officer of NHIF made a guarantee on behalf of Eurobank to enable Consolidated Bank to use the fixed deposit as security. Again, Appendix E2. When Eurobank defaulted on payment, Consolidated Bank was unable to recover payment and therefore offset the 49.5 million from the total amount of 600 million. See attached letter of set-off, Appendix E3. On 20th February 2003, the Central Bank of Kenya appointed Deposit Protection Fund Board to liquidate and wind up operations of Eurobank Limited. Therefore, in its capacity as statutory liquidator, the Deposit Protection Fund Board had taken over all the affairs of Eurobank Limited, including all records. The fund had deposited funds with Eurobank Limited, and at the time of liquidation, therefore, a lawyer, Ahmed Nasir, Abdikadil and Company Advocates, was appointed to pursue the matter of Eurobank with a view to pursuing the directors of the bank on 16 June 2003. Following the advice of the advocate, a suit was filed against the following. 1. Deposit Protection Fund. 2. Eurobank Limited. 3. Solomon Bundi Mudhamia. 4. John Paul Washira Munge. 5. Fidosh Ibrahim Jamal. 6. Hari Mutuma Kadurima. The sixth defendant filed a Sheba summon seeking orders that the plaintiff's suit be struck out against him. Justice L. Jagi delivered a ruling on 29th October 2003, where he directed that since the suit against the sixth defendant had been withdrawn, the plaintiff should pay the sixth defendant cost of the suit, which was to be taxed. The sixth defendant filed a bill of costs on 4th November 2003, where he claimed 11,072,767 shillings. The bill was taxed, and a ruling delivered on 31st March 2004 taxed at 8,282,772. The fund filed an objection to the registrar's ruling on 8 August 2004 and further filed a chamber summons seeking to set aside the taxing master's ruling in its entirety. Justice Kamau, who dismissed the fund's application with costs to the sixth defendant, delivered a ruling on this application on 28th July 2014. By a letter dated 18th December 2014, the advocates of the sixth defendant requested for the payment of their taxed costs and accrued interests, as well as the costs of the dismissed application, making a total of 19,231,031. The advocates of the fund engaged the sixth defendant to have them reduce the amount they were demanding. The sixth defendant accepted a sum of 10 million as the final settlement. The first and second defendant also filed an application to strike out the suit against them. The parties made their submissions about the suit, and on 28 June 2013, the judge allowed the application seeking to have the matter struck out. The court allowed the application with costs to the first and second defendant. On 14th May 2014, the first and second defendant filed their bill of costs at shillings 23,480,914. The fund's advocates objected to the same through written submissions. The ruling was delivered on 16th November. The bill was taxed at 10 million. Because the advocates had filed to set down the matter for hearing on 20th April 2018 from the firm of Ahmed Nasir Abdikadir and Company Advocates, and on 6th September 2018, the firm of Migos Ogama and Company was instructed to take up the matter as evidenced in the letter HFLD 19 Vol 2 in brackets 12 Appendix E4. The matter was handled by the Inspectorate of State Corporations, which was of the view that the fund had no capacity to provide guarantee for a loan to a private bank. The Inspectorate of State Corporations further noted that Consolidated Bank should pay back the amount of 49.5 million. Attached is the report from the Inspector General, Appendix E5. 21st report of PIC, committee recommendations. Chair, the fund acknowledges the 21st PIC report observation that the action be taken by relevant government agencies as recommended in its 19th report. PIC also recommended in its 21st report that the query should be excluded from subsequent reports of Auditor General, provided that management makes full disclosure of this unresolved matter in its financial statement as required by IAS number 37, page 309 of 21st PIC report, Appendix E6. Management makes full disclosure on the matter in its annual reports as recommended in the 21st PIC committee report. Current status. Chairman, the matter HCC number 505 of 2003 came up before Lady Justice Joki Mwangi on the 25th of May 2023 for notice to show cause why it should not be dismissed for non-prosecution. The fund advocate successfully defended the notice to show cause, and the court fixed the case for hearing on 28 September 2023. The court further directed the parties to file any additional documents they may wish to rely on within 30 days. Management has made full disclosure of the matter in its 2020-2021 financial statements as required by IAS and as recommended in the 21st PIC report. Additionally, as per letter Ref MO stroke N stroke 0341 stroke 16 stroke 18 dated 13th June 2023, the matter came up for hearing on 28 September 2023. However, it was set aside and parties were asked to obtain a new date in the registry. Thank you, Chair.
Thank you, CEO. Members, here it is. Very, very interesting indeed, Engineer Kamau. From current land dispute to resource center, which was never built, to car park, which was cost escalated, to Eurobond saga, to granting a private farm. Now, one's application being dismissed, and you are ending up by telling us that the court also have sent you to look for another date. This is the history of NHIF. Very sad indeed. But members, your reactions.
Chair, thank you. First, I want to start with information on 1.2 and 2, which were not captured by our secretariat. I requested for 1.2, doubtful work in progress at Karen, a letter authorizing the NHIF to pay the work which were doubtful, which the CEO admitted that there were no approval prior to procurement. So we needed the letter from the parent ministry authorizing this payment. It was not captured. He never responded to it. Then on query 2, 2.0, construction of multi-story car park. Also, I asked about the relevancy of Appendix C3, which was not giving us more detail, so it can make it more relevant to the question. And then also the approvals of the board, which approved the extra work of the lift, and the technical reports, which authorizes the issue of the extra lift, and also the report of the board, which withdrew the issue of the lift. Those were not captured. I request that they be part of what will be submitted so that it can help us. The board meeting approval, the technical report, and even when they change from using the lift to other things. And then I ask also about what is called the variation from 900 million to 2 point something billion, which is over 100% variation. So those areas, nobody has responded to them. So in their submission, they better give those ones. Thank you, Chair.
Well delivered. If you could just take notes, we take all the comments and then we react to them. Any Honorable Mandato?
Chair, I think on the issue of the loan to MTRH, the payment of the legal fees, which is 40 million, maybe the fund can provide some further clarification, because to the best of my knowledge, even if they were to pay us per the advocate's remuneration schedule, and the Mercy is here to maybe guide on that, I think it's generally about 2.5% for this sort of transactions. If you look at the Advocates Remuneration Act of 2014, I think this sort of amounts should be attracting in the range of 2.5% for figures above 2 million. So the fact that the board here chose to pay 25%, because the payment is 40 million on a loan of 312. So if you're saying the loan is 312 is the subject, the fee of 40 looks way out of the advocate's remuneration schedule. So maybe can you clarify that?
Thank you. Bishop, you are quiet today on governance. Are you overwhelmed with what is going on?
I'm asking on
No,
Today, Chair, we are getting explanation from the government view. Looks like some governance structures have been improved. Now it is able to coherently present, though lacking the gaps that existed were there. So that's why I'm quiet today. I see the chairman has done, the board has done good work. We've returned them, I think, twice, 3 times, and we had a problem with governance. Today, the governance is presenting now the organization as it is, the fund as it is. And we are looking at that. I don't think I have an issue. The only issue I had was the Department of Law, the legal department, that never advised the presentation of the document. These others are figures, and it is what it is. Okay. I'm not.
Well, later said he has also been covering over there. That's fine.
And you, Chair.
From my point of view,
I have to correct myself.
yes.
And I must say, maybe you need to look at this. Actually, I think for figures above 250 million, the percentage should be 1%. You could check this for us, the advocacy remuneration schedule, because that should be, at worst case, a guidance for all legal fees.
Mine is very short. It was good news to me to hear that MTRH has agreed. But you also threw me off when you say the signature is to be appended. So agreement without signature, if you can give us that evidence, I think that will be good news. And lastly, on page 20, the second paragraph, they said something here which I need to get my, the full disclosure, which the PIC, the 21st PIC committee report wanted. I don't know, Secretary, whether you can respond to this, but is it there so that we exclude this again and again in our report? Or what did you mean by this response? Maybe you can clarify as well. Seeing none, I think you are on. You can proceed.
Thank you, Chair. Indeed, I note the requests by the Honourable Member in 1.2, doubtful work in progress, and will endeavor to provide the letter from MOH authorizing NHIF to make the payment. So I will dig my archives and I will provide the documents as requested. Then Appendix C3, Chair. How relevant or not relevant? Chair, this C3 has on its page 13 of 46 compensation events, and this is part of what guided management, the then management and board, on how to compensate the contractor NK Brothers. That is its relevance, Chair. Chair, we shall endeavor to provide approvals for the additional work of the lifts and the withdrawal of the lifts and the valuations to the contract amount. Chair, in response to Mheshimiwa Wandeto's question about the legal fees, I note that the request by MTLH for loan was for a higher amount than what was eventually disbursed. I think it was for 1.7 billion, the request. And therefore, the legal fees, which should not be the case, Chair, was calculated based on the amount requested and not the amount disbursed. This, Chair, I will push together documents to support my answer. Thank you, Mheshimiwa Bishop Emeritus, for noting improved governance in our presentation and requesting for the input of the legal team. The document being presented before this committee, Chair, was put together by a team across the various disciplines that are mentioned in this. So I am only the face of the organization, but there is input from procurement, from legal, from finance, from operations, and from every other department. Thank you, Vice Chair, for commending us for the negotiations that have gone on to a point where the CEO of MTLH, though he is out of the office, he is now at Kapkatet, confirming that he agrees with every clause of the contract and he is ready to sign on Monday when back in the office. Chair, with your permission, I will avail a copy of the signed agreement immediately after it is signed.
Session Chair. Yes. While I join the Bishop in commending the NHIF team today for a much more coherent presentation, I think what the CEO has just said about the legal fees being based on a higher price than what was actually requested, than what was actually awarded, can be challenged, because on page 14 of his document, the last paragraph of page 14, NHIF wrote to MMA advocates on that date, reference that, requesting them to prepare a finance contract between NHIF and MTRH for approved amount of 312, 669, 869. So I do not know whether the CEO wishes to correct himself from that statement.
CEO.
Thank you, Chair. Indeed, the contents of the paragraph referred to by Mheshimiwa Wadetro are accurate and should have been the one, this amount, 312,669, should have been the reference amount when calculating legal fees. However, we note in records available to us that the base amount was different, and are engaging the advocates with a view for them or to use the right amount. Even MTLH are concerned about the amount of legal fees paid. Thank you, Chair.
Thank you so much. I hope Honorable Mascara was here, but his concern, I think you said you're going to address it. That was the approval, yes, and also details of the contract. As it is now, this is not a contract. The contract is always signed, and also permission of incurring those variations. From this end, I would say, yes, we are making progress, but I'm happy that you are seeing what the organization is, especially when you talk about value for money for Kenyans. All this we have been doing here, you can weigh for yourself. Because of time, I want to give the auditors a few minutes to comment, and then we will close up with the NHIF, just brief comment if possible. Yes, auditors. Director, you on?
Thank you, Chair. On the issue of expanding a paragraph from our audit report in the subsequent report, this there is an issue to that effect on 21st report, whereby they have said that if it is made, our full disclosure is made in accordance with IAS 37. In accordance with IAS 37. Looking at the financial statement, they have not made any disclosure to that effect. And again, even if they make a disclosure, any subsequent pronouncement by the Public Investment Committee supersedes the former. If you look at the Public Investment Committee report, 22nd report, it now recommends that the EACC and DCI extend the investigation to the entire board during the period under review. And this was informed by their observation, whereby they said the decision to invest the 600 million in Consolidated Bank was arrived at by the entire board of management. So the issue of expanding it from our report until the action is taken by EACC and DCI, so that we can expand it from our report.
Thank you for bringing that up. So this one, you are not off the hook yet. As the auditors have said, of course, each PIC can revisit and can pronounce themselves anew. So thank you, Director, for bringing that up. Yes, to you again, NHIF. Chair, do you have any closing remark?
Thank you, Chair. Just to appreciate the committee. We are working. I've observed. In this situation, I've been an accounting, and I've sat before PIC. We are going to improve any gaps, and we will follow up management to ensure that everything that was requested here comes. That is why I was accompanied by 2 board members, just to have a feel of where we are. It's not the place we would want to be, but I think it's a place we can get. The head of public service has said that we should work towards zero-fault audit. And for us, I think there's a lot of work to be done to get to that level. But I thank the committee for its engagement. Thank you.
CEO.
Thank you very much, Chair and committee.